Good afternoon, everybody. I'm Andrea Pather, a senior associate in the property practice group at Patswane Henny Attorneys. Today, I'm wrapping up the last segment in our series of the Property Practitioners Act. I'm going to be looking at the conduct of property practitioners, what is regarded as sanctionable conduct, and the penalties that you would face if you were found guilty of such sanctionable conduct under the Act. Chapter 9 starts off with Section 60, which looks at who Chapter 9 and 10 is applicable to. Interestingly, it is applicable to any person who performs any function or renders any service as a property practitioner, irrespective of whether or not they are registered with the authority. This means that you can still be found guilty of sanctionable conduct even if you are not registered with the authority. There's also going to be a code of conduct that will come into fruition at a time to be announced by the minister after consultation with the authority. This code of conduct will apply to all property practitioners. I'm going to go through a few examples contained in the Act of what is considered as sanctionable conduct. I advise that you go and look at the Act as it contains many more examples than I will be discussing here today. The first one is if a property practitioner in the same transaction acts on behalf of two or more persons whose interests aren't materially same in that transaction, and he receives remuneration for acting on behalf of those two persons and they don't agree in writing, that would be deemed as sanctionable conduct. Another one would be if the property practitioner fails to pay money which becomes due and payable within 1 month to the fund. Another example would be if the property practitioner fails to furnish the authority with any information that the authority requires in performing its actions under this Act. If he fails to comply or he contravenes the code of conduct, if he commits an offense involving any act of dishonesty, if he fails to inform the authority of a change of his details within 14 days of changing those details, and if he differentiates with any customer on the basis of race, gender, sex, marital status, or ethnic origin, that will be considered as sanctionable conduct. It is important to note that the correction or ratification of these acts, it does not constitute a defense to the sanctionable conduct. If you are found guilty as a property practitioner, the authority may then withdraw your Fidelity Fund certificate, they may impose a fine, or they may reprimand the practitioner and note its transgressions on its website. Even if that practitioner has been acquitted or convicted by a court of law in a criminal charge, it is not a bar to proceedings under this Act. It is very important to note what constitutes sanctionable conduct so we as property practitioners can steer away and steer clear of those things. Thank you so much for joining us.